Go bold at boldip.com.
Hey everybody, welcome to the Bold Inventor Show. I'm JD Houvener, your host, with Matt Kullsup, my trusty co-host.
Hello.
Matt, welcome back to the States.
Thanks, man. Yeah, it's been a month. Been out of town, out in Montana, chasing some elk around, and then in Italy the last couple of weeks with my wife for our 15th anniversary. So, yeah.
Oh man, that's so good.
It's hard. It's real hard being me sometimes. No, I'm good, man. How are you doing?
I'm doing great. Been good.
You're looking great.
Thank you. I
for those
appreciate that.
At home or in the car, JD's wearing a sports coat today.
Yes, I am.
He's looking real sharp.
Feeling a little more sophisticated. You put the jacket on, it's this whole mental thing. It's just, you just level up.
Game time, even if you're wearing shorts or pajamas.
Oh, I'm definitely wearing shorts. And I cannot button this thing comfortably, but that's okay. No one can tell. It's chest up.
JD likes to party.
Yeah, that's right. I've got the microphone here as well, upgrading the microphone.
You have a little lapel on.
Lapel. So this is one of my coaches I'm working with. As you know, everybody's got a coach these days. I got a coach, and he's working on my videos.
Yeah, I think that's the thing. If you have a business coach, you should ask your business coach if they have a business coach, because you want the guy or the gal who's got his own business coach.
You want at least 3 layers of coaches minimum.
Yep. The grand coach, the coach.
Yeah, speaking of coaching, I've been coaching soccer, trying to harness the Ted Lasso in me, right? Best I can.
Man, believe.
Oh, and we need it so bad. So, I mean, this is rec league soccer, okay?
Yeah.
Rec league. And we're surrounded by really amazing soccer players out here in the middle of central Washington. There's not a whole lot going on.
Yeah.
Given that, the rec league is competitive, okay? Right? And so they say it's supposed to be, basically filled in. No. I sort of got the leftovers. It's unfortunately the way it works. It's a little sad, but the coaches can be requested. And so I'm a new coach coming in. I get to just love on the folks that just don't have anywhere to go, didn't have a recommendation, didn't get picked.
So you're the coach for in the land of misfit toys.
Yeah.
They go to you.
Oh, I don't know that one. Hold on. The land of misfit toy. What?
When we were kids, there was a Christmas movie with polar bears and stuff like that, and elves, and it was a clay animation kind of thing, stop motion animation. I forget the name of it. Somebody in the comments section write it down. But
please help us out.
Land of misfit toys.
Yes. Oh my gosh, this is good. It's actually really fun, and I'm connecting with the kid, with the athletes. My daughter is not complaining. I'm doing a decent enough job. She's
Oh, that's great. The one time I coached my daughter's soccer team did not go well.
Okay. Yeah.
Because I was dad, and she was constantly trying to get to dad, but
for sure.
Rudolph the Red-Nosed Reindeer in the Island of the Misfit Toys.
My goodness, you nailed it. You got it. Something
like that.
Okay.
Well, good for you for coaching. I think I'm going to coach my other daughter's team, I think, this winter and spring. Because
good.
Yeah, you and I both love soccer. It's a great sport for kids to play, and
totally. And you played at the semi-pro level.
Nah, I played very competitively throughout my teens and early 20s.
That's awesome, man. Well, good. Well, I definitely far less experience. I did 1 year in second grade.
Nice.
On the trophy, I think it's somewhere, it says Bigfoot. That was my job. Defender, just booted as hard as I could.
Yep, just blast that ball, man. Up and out.
Kick it out. Oh, man. Let's do it. Well, today we're talking about not just soccer, coaching, and catching up about our travels. We're talking about patents and trademarks, which we always do here on the show. And we do encourage live participation. So if you're out there and you're watching us, awesome. Know that we're not going to be talking about anything confidential, so please hold that. But ask a question, ask hypothetical. If you're just kind of somewhere in the process, maybe you're started on your own application, fire away. We'd love to help out if we can. And if not, we can set up time to talk confidentially with our team. But our topic today is going to be about getting, what to do after you get the patent, after you get the trademark registered. There is sort of this, second half of the journey we want to talk about. So that'll be we'll bring that up here as we get after our Q&A session. And then we have a Bold Bite in store. I've got a good one here. One quick update for me, which is related to the Bold Bite. We got a puppy. Hypoallergenic. Wasn't sure if we were going to do it, but we basically have the kids on some really cool allergy shots now. They're under control. So I thought I'd give it a shot, and so far so good.
Nice. Now, what kind of puppy did you get?
It's a golden doodle.
Yeah.
And he is black with a little white patch right here.
Nice.
He's
Got a little
so
soul
soft.
patch, a little white soul patch.
Yes.
What's his name?
His name is Cal.
Cal.
After Cal Raleigh, the Mariners catcher, been doing great for us. I'm not a huge Mariners fan, but that was what the name of the dog was when we picked him up. So you know what? 3 months old. So still very much a puppy. He was the most independent one. The kids and I got to go over to Idaho to pick out one of 3.
Cool.
And it was a lot for them because they're not familiar with dogs, not comfortable. So they liked the chill, relaxed, calm one. I was like, yes, let's do that.
That's the one to get.
Yep. So we got Cal. He's wonderful. But we're going to go through some training and all that. So anyway, Bold Bites. We're going to be critiquing a Shark Tank pitch related to dogs.
Cool.
Well, I say animals. It's kind of a cool solution, something you might think about.
Right on. Looking forward to it.
All right, Matt. So let's let's get ready. I've got 5 questions that have come in from our lovely Amira, who has been kind enough to scour the internet for all of your questions. I know we don't always have any live questions.
Yep.
But if we do have any, we're welcome to take those. Happy to take them. So first one, I'll put you on the spot. Just you've been on a little bit of a break, so
sure.
Test your strength here with a Quora question with regard to copyright / trademark question. Let's see.
Sure.
Yeah. Okay, this one's kind of a little bit generic. Let me kind of look around a little bit. There's some music here. Oh, here we go. All right. Barbie question. Love it.
Yes.
Okay. Barbie everywhere. I've got a podcast called the Barbie Life 2.0 podcast. Don't we all? Do you think Mattel will sue me for trademark infringement?
Probably.
Okay. Walk us through the analysis. If they're just getting started, my head says you're not going to get that letter right away.
So let's talk a little bit about it. So, Mattel owns Barbie. Barbie is, an incredibly famous trademark, here in the United States and abroad for that matter. But when it comes to famous trademarks, trademark holders who own famous trademarks, what I would consider Barbie to be a famous trademark, kind of like Nike, right? Or Apple computers. Right. Facebook, right? These are all famous brands, and they get a heightened level of protection at the USPTO, both from a registration perspective and an enforcement perspective. You have much larger rights as a famous company or as a famous brand owner than you do if you're just a regular schmo like me, right?
And this is sort of, I don't know, just a quick aside. This is like call it second level. Right? This isn't the name of a company. This is the name of a product that is you think is garnered enough to say, yeah, this is famous.
I would be
cool,
very
right?
confident to say that they are a famous brand, in which case they get a larger swath of protection, even outside of their normal, channels of commerce, right? So you think of Barbie, you think of, typically you think of like obviously the dolls, right?
Right.
The movie, the TV shows, apparel, potentially online store, e-commerce stuff, accessories. But predominantly they're going to be like in that class 28, toy category at the USPTO. What this individual is asking, the Barbie Life is a podcast, right? That's going to be class 41, which is the same class that things like the Barbie movie are going to be in. Any Barbie shows or cartoons are going to be in that same class. So I think as an examiner at the USPTO, if I saw this application, I would think to myself, okay, twofold, right? I immediately think Barbie. Like, is this having to do with Barbie? If it's not having to do with Barbie, is it in a class that could conceivably be related to what Mattel's doing with Barbie, currently? And if I said yes, then there's probably your office action right there. But, beyond that, even if there was no Barbie movie or Barbie cartoons potentially, right, you'd have to think to yourself as an examiner, is Barbie a famous trademark? And if so, do I need to kind of give it a larger swath of protection, outside of the classes that it currently resides in. But I can almost guarantee Mattel's got Barbie registered in a dozen classes at the USPTO for just abstract, random stuff that you would never think would be branded Barbie, but it is. So, and I can guarantee like Mattel, they're gonna, crack down on this pretty hard. Yeah. Because they have attorneys. I guarantee there's one or two attorneys that their full-time job is just to enforce Barbie, copyright and trademark infringements.
And I think that enforcement part is what we're going to talk about maybe later today, but sort of a foreshadowing in that some of these bigger brands, like you said, they have the resources to have attorneys, maybe even staff, watch for applications as they go through. Even if this one were allowed, if you will, they'll likely oppose it during the opposition
they'll
period.
almost for sure oppose the trademark application if there was an application. Even if there's not an application, you're likely to get on their radar because as trademark attorneys, we typically subscribe to a bunch of watch services that look not just for like new applications at the USPTO, but common law or unregistered usages of the brand.
Okay. I don't take too much long on this. One thought I had was...
It's a good question. I would, throw the flag on that one pretty quick.
Very good. Thinking a little, law school questions type stuff. If they're going for a critique, maybe they're going to critique the Barbie show on the podcast. It's perhaps a arguable fair use on copyright terms. Is there any avenue to try to protect the podcast, given that it's a critique or review, if they disclaim the word Barbie, or is it still going to be an issue?
It's still going to be an issue. Like they couldn't register and disclaim the word Barbie. Barbie Life 2.0 podcast because it's pretty descriptive potentially. Podcast 2.0, like second version, it's pretty descriptive. So I don't think there's a whole lot here there's not a lot of meat on the bones to like try to get around the potential issue at the USPTO.
Awesome. So, we knocked that one out of the park, Matt.
Good.
Thank you for that. Okay, let's jump over to patent side. And again, fire over your question if you've got one. If you're listening, we're happy to take that as a priority. Looks like this one is the quick question is, can I patent this? And it looks like it's an international question.
You can try.
Yeah, exactly. And it's like, can you sue me? Yes, you can.
Yes, you can.
So I live in France, but I didn't know the U.S. law also. My product is a simple mix of a torrefied plant. I'm going to have to Google that word. Torrefied.
Yeah, I don't know that word either.
I'm horrified with that term. With water, which is intended to treat a specific condition. Is it possible to patent for this? Okay. Well, what do you got, Matt, on the old conch?
I'm looking this up. A torrefied plant. Well, that's a biochemical plant. Okay. I don't know what torrefied plant with water. I don't even know what that means.
Okay. Well, let's say it's
biomass. Something about biomass.
Biomass. Well, let's see. I do want to offer up that there are three types of patents you can get. A design patent, which is largely about the way an object that can be made looks. Okay, that's a design patent. Second type of patent is a utility patent, which governs functionality of what the invention does. Mm-hmm. There is a third type called a plant patent. I don't know if this is where this is going, but you can get a patent on a specific botanical strain, a new plant species. The major criteria, major specification there, requirement, I should say, is it has to be man-made, right? You have to have some human input. And if torrefied means that it was created in a lab, in other words, it was modified, that the strain of plant was grafted or in any way manipulated, and it changed from its natural form, thumbs up, so long as it's novel and non-obvious above and beyond other plants, okay? And so you can secure patents on plants, as long as they're asexual, reproducible, right, in a lab, you can get them all going. This seems like it could be a bit of a utility as well, because it's treating a condition. I know there's obviously separate rules regarding the FDA, right, making such claims for certain things. But aside from that, compliance, if it does have a benefit, right, if you're combining a plant with water, gosh, that seems so inert and natural to me. Seems obvious. Okay, just kind of the red flags are going up in terms of obviousness. I mean, going back to like what, third, fourth grade plants, or what does a plant need, right? Sun,
dry out the plant, grind it up, and add water.
Yeah. So I don't know. Yeah, and this is a mix. So if there's something else going on here that seems novel, it's worth a shot. Whether you live in France or anywhere in the world, if you're seeking a patent in that country's laws will govern. And then if you want to seek patent protection outside of that, there is a really cool treaty called the Patent Cooperation Treaty, where you can get protection in multiple countries through that vehicle. So have a look, talk to a local attorney, a U.S. attorney. Bold Patents would be a great option. We'll provide a link for you to schedule time to talk more about that. Thanks for helping me look up Torified.
Still not
probably saying it wrong. But.
Still not sure what it means.
Yeah. Okay. We'll take any question. We won't be Torified. Okay, we have a longer question. Oh, we did that one last time. That was the shaver. Oh man, this was a long one. We got to dig in. All right,
do it. Buckle up.
Let's crack our knuckles. We're here. We're dedicated. All right. Okay, let me see if I can just pull this thing up. Goodness, look at this. Yes. I formed an LLC.
Great.
Beginning of the year. I've been working on building my company, but haven't yet opened for business. Before I do, I want to trademark 2 logos and the company name. I'm getting so confused on the cost of the process because the trademark process. I don't really understand classes versus trademark IDs versus logos. I have 2 official logos that I've made. I'm assuming just, designs, drawings. Yeah. So am I right? I'm paying for 3 applications and 3 trademarks plus each class. This is going to be thousands. Crying emoji. Matt, can you save them? Is this what are your thoughts here?
Yeah. So lots to unpack there. So it sounds like this individual has 3 different things they want to register: 2 logos and a name. So 2 design marks, what we call them in trademark land, and a word mark. And then they are correct that each of those is its own separate application. So you have 3 separate brands you're trying to register, and then each of those 3 brands could be registered in multiple classes at the USPTO, depending on the product or the goods offered. So it sounds like there's probably 2 different logos, a word mark, and maybe one's used just on the website for the online store, maybe one's used for the product. Maybe they're all used interchangeably, potentially. So yeah, you certainly have probably 3 different trademark applications at the USPTO, which is each $250 in government fees.
Yep.
But it's possible that each of those 3 different applications falls into multiple classes at the USPTO, and you might want to file each application with multiple international classes, or file each of those international classes for each of those brands separately. So. Okay. If all of you're in 3 classes, you could do 3 applications and 9 classes total, or you could just do 9 individual applications.
Okay. And are they far off? It sounds like it might be thousands just in the USPTO fees.
Yeah.
On top of the legal fees, right?
Could be. Yeah. Okay. Yeah. So each application is $250. And it sounds like they may have 3, so $750.
Okay.
And then attorney's fees are considerably higher than that.
Yeah, absolutely. And for someone that doesn't always have all the cash in the world, do you think that would be a wise choice for someone really bootstrapped to go file?
No, I definitely don't. Even for clients that aren't bootstrapped for cash, we still typically are going to take a look at what they're trying to do, where they're trying to make their money, and find the appropriate application class that's going to give them maximum protection for the least amount of investment. So, if you had 3 different trademarks, I'd probably look at that and say, like, you're just a new business. Like, let's just focus in on the most important classes at this point. There could also be a way to incorporate those 2 design marks into a single design mark, right? So maybe you include the logo, or you include the slogan in the logo, and then instead of having to file 2 different logos, you file just the one. So there's some benefits to working with the trademark attorney who's got the experience to kind of point you in the right direction, tell you what's important, what's not important.
Very, very good. Love it. All right, let's take one on the patent side here. Okay, we've done a few of these. We have to mark these down. Let's do this. Let's do this one here. We had some OSHA regulations. This one's a little lengthy as well, but it's all right. This is out of our Reddit group. Very active. Okay, I created a safety device after discovering our entire company has been violating an OSHA regulation. We're looking at multiple sites across the US and the world. I presented the device to our corporate HQ, and they absolutely loved the idea. They want me to create a bunch of the devices for our sites. The device is a simple 3D printed part, but it fixes this OSHA issue as well as solves a potentially hazardous situation. Should I patent it? Sounds like it. The device is used in our company machinery. Let's see here. And they don't actually have any kind of device for this. Well, I really don't care about making money. I call your bluff.
But
from the sounds of it, I will make sure everybody's safe. Oh, there it is. But if I can, why not? I read filing for patent is insanely expensive, and if I should file for one, I would want to make these for the company before filing. Thoughts? Okay.
I know where this is going. I know where this is going. I know where you're going to go with this, JD.
Well, this was our topic, 2-3 months ago or a month ago? Right. So employee-employer situation, take a look at your employment agreement. I think it's where I would start.
Yep.
It sounds like, based on the fact that someone asked you to look into this, or you were aware of an OSHA regulation, if your boss asked you to, if your job is to develop devices or solutions like this, and you're an employee, odds are your employment agreement is going to require you to assign your inventions to the company. However, if you're a third party or a contractor and you're not bound to assigning your inventions, you want to make sure that you have independent ownership well before you pay out of pocket, filing fees, hiring an attorney, digging in, and investing your own resources on this. There's perhaps even a third option. If the company is small, perhaps, maybe they're facing some financial hardships, they may be willing to waive their assignment privileges and allow you to own this individually. Right? If you're going to put up your own money to hire an attorney or even do your own research and get the application filed, that's a big investment of your time and effort, and certainly money. If you hire an attorney, you want to make sure you can reap the benefits of that. So that's the first issue, is making sure you decide and confirm ownership. Secondly, I think, if this is a problem your company has and you think it could be applicable to others, and even then more so if you think it's a simple product or a device, that all sounds like it's something you want to seek patent protection for, because someone, as soon as you sell this or it gets out to the public, you bet your competition or even OSHA will be telling others, hey, you should put this thing on your machine. And you want to make sure that they're not going to be able to reverse engineer it and make their own. So a great option is to look for patent protection, get it filed. And who knows, sounds like this even could be something like a standard on for the industry, safety standard. Yep. And what a home run that would be if you're able to, garner the benefits of that for 20 plus years.
Yeah, if you were to own it. But you're 100% spot on with that analysis. I mean, first things first is figure out, can you actually even own this thing, separate and apart from the company you work for?
Yeah.
Because it sounds to me like that's going to be the company's.
Totally. Yeah. Yeah, it's kind of fun. I should know this phrase memorized by now, right? But invention, what is it? Necessity
is the mother of all inventions.
Mother of all inventions, right? So there was a problem. We need to solve this OSHA violation invention.
Right. Yep.
Love it. We like you too, Jonathan. Big shout out to you. You got some love going both of our directions there, Matt. Yeah, we are a good team. Appreciate that. Any questions you've got, fire away. We got some folks online. We'll do one more Q&A question. I realize some of these that were marked as unanswered, but we did get to them already. One more on the trademark side for you, sir. Let's do. Okay. Over in the Quora bucket. Oh, you know what? We did it. We answered them all, Matt.
Did it.
Let's go over to Avo and see if there's anything over there. There is some stuff.
Cool.
Okay.
Let me at it.
All right. We had a t-shirt question, Matt. Can I create and sell a t-shirt with an image of Jesus wearing a New York Mets cap?
No. I mean, yeah, you can create anything you want. You can sue anyone you want. You can create anything you want. But, can you register anything you want? No. And you could, potentially register a likeness of Jesus, but wearing a Mets hat,
Not going to work.
Not going to work unless, of course, you make it like an homage to the Mets logo, but not exactly, right? So it looks similar. Maybe it's just the M in the style of the Mets logo. That could potentially be registrable. Okay. But it's not just, one of the things that I think a lot of our clients or any apparel client is going to get confused about is the fact that just because you have a t-shirt company does not mean you have trademark rights. So in order to have trademark rights in your apparel, you have to treat your branded apparel like it's branded. So if you just have a picture of, Jesus with a Mets hat on the front of your shirt, that's not acting as a source identifier for trademark purposes. It needs to be like considered, someone would have to see that and be like, that's a brand, right? I know that brand, right? And typically we signify that in apparel for trademark registration purposes by putting it like in the upper left breast pocket area for shirt, or, on a label, or on a hang tag attached to the shirt. That's how we prove that the trademark is actually being used as a trademark and it's not just ornamentation or decoration.
Perfect.
But yeah, you definitely want to avoid, there are some limitations too around historical figures and presidents and things like that you have to avoid potentially, likenesses, that sort of thing. But as far as I know, like you can put Jesus on a t-shirt and register with the USPTO so long as it's unique to you and it's distinctive, meaning it actually serves as, a source identifier, i.e. a trademark.
Got it. Yeah, I've got one more I'm going to sneak in on you. I found this is a good question here out of Avo as well. And it's a question for a client that is currently using LegalZoom for their legal services. We're not going to hold any punches. I paid LegalZoom a year ago. Yeah, right. I paid LegalZoom a year ago to represent me. I wanted to start a coffee company and have a logo and name. I'll follow their advice in giving a logo in addition to a name. And now 1 year later, they're telling me that there's a problem, a refusal for the company I'm starting. There's another name that's a song that LegalZoom is telling me might preclude me from getting my trademark. My coffee company is called Get the Fuck Up.
Yeah.
You could certainly pronounce that differently. Yet there's a song called, apparently, with a similar title, Get the Blank Up Out of Bed.
Oh, I know this one. This is actually my alarm in the morning.
Are you serious?
Yes. Yes. This is actually my alarm, and it's like a 30-second jingle, basically. I'll send it to you. I'll send it to you after the show.
Sounds good. I want to keep the podcast relatively clean. But
yeah.
So obviously, I think if you're following along, this is a song. Someone's trying to get a coffee company. I don't understand how
that should not be a problem at all. Right? So, a song is not registrable as a trademark by itself, right? It has to be like used as a trademark, and songs they fall under copyright. They don't fall under trademarks. A music album could potentially be registered as a trademark, just like a series of books could be. Yep. But not an individual song. Even if the song was registered, it's going to be an entirely different class than coffee product, class 30, or, cafe coffee services, class 43. So I'd want to know more about what, Zoom or LegalZoom is saying. Or LegalZoom, is that right?
Yeah, LegalZoom. Yeah, right.
LegalZoom is saying, because that doesn't make a lot of sense to me.
Yeah, they're saying there's a possible refusal. That doesn't seem to make sense. Okay, maybe they're kind of digging for an office action.
Yeah, and just so people at home are aware too, like there's no ban against swear words or profanity at the USPTO anymore. It used to be that you couldn't file things that were scandalous at the USPTO, like the F word and stuff like that. But that's not the case anymore. You can, as long as you're using it as a trademark, it can be registered as a trademark.
There you go.
A lot of the times you'll find those obscenities and that kind of stuff doesn't actually function as a trademark.
Very good.
I remember I had a client that had like the F word printed on like a bunch of different products, right? And the USPTO was like this is not trademark. You're just using obscenity on a piece of luggage, right?
Yeah. I when you said that, I sort of imagined those words kind of in a pattern, right? Yeah. Kind of like the Chanel, and perhaps
Yeah, that's exactly how the client was using it. And it wasn't the F word, it was something else, but it's similar to that concept. But ultimately, we were able to register it because during the application process, the USPTO changed their rules around obscenity, and yeah.
So they got lucky. They
Yeah,
filed
lucky.
before or maybe as the.
Yeah, they filed, and then they had an office action. They contacted me, and then I got involved. And during the process, a new ruling came out. A rare ruling came out that changed, the trademark landscape.
Yeah.
Still waiting for the cannabis landscape to change at the USPTO. I was really thinking that would happen anytime in the last couple of years during this administration.
So the word cannabis, pot, those types of things?
Yeah, cannabis products are not registrable at the USPTO. Some hemp-derived cannabis products are, so long as they contain less than 0.03% THC by dry weight volume. But
yeah, and that's that 2018 Farm Bill, right? That older.
Yeah. And that did change things, but we thought, and we were basically told on some level by the USPTO that the change, against the federal prohibition on cannabis at the USPTO was going to be modified at some point, but we're still getting denials for clients.
Okay, good stuff, Matt. All right, let's transition here. We did a lot of Q&A. We'll still welcome any live questions, though. We're going to jump to our topic for the day, which is post-grant, post-registration. We talked a lot about all the work I'm doing in researching and applying for. We just got done talking about all those oppositions, but let's say the champagne cork has been popped. You've got the registration on the trademark side, or you've got the patent now granted, fully granted. What are some things that are coming, right? What else should I be thinking about as a trademark holder looking ahead? Matt, I'll start with trademarks and we'll go to the patents.
Yeah, no, good question, right? So I think, if you have a trademark registration, the first thing to do is make sure you update your branding to reflect the fact that you have a registered trademark. So put the circle R, on the most prominently displayed, parts of your brand. So maybe the website, maybe the products, right? Maybe the footer of the website, any marketing, advertising, at least the first time you use the brand, put the registered trademark symbol behind it. That's important. If you're an online seller, I'd recommend, getting the Amazon brand registry process started. That's kind of a pain, but if you have a registration, Amazon will allow you to participate in its brand registry, which gets you a bunch of really great benefits, like custom landing pages for your products, pictures, videos, additional colors, copy, that sort of stuff. That's a big thing that you should look at doing after you get your registration. If the reason you've registered your product in the first place is because you're getting knocked off, you can obviously contact Customs and Border Protection. And if you have an idea of where the products are coming from, or when they're supposed to arrive, you can have CBP basically take those products and put them aside, and they go through a process for trademark infringement.
As the owner of the trademark, is it something that I would want to do, or should I hire counsel to help me?
You're definitely going to want to hire someone who deals with CBP. Your trademark, Customs and Border Protection. Your typical trademark attorney like me, not going to know anything about working with them.
Okay.
But somebody who works with customs, imports, exports all day should have a pretty good sense of how to do that.
Perfect. And if anyone has a question here, would you be able to send them off to someone that could help them out? Do you have a referral partner that can do that?
Yeah, we can find someone.
Perfect.
And then beyond registering the trademark with Amazon and maybe CBP, you could also just put the renewal dates in your calendar. That's an important thing, unless you're working with an attorney and they have a docketing system, in which case we'll docket it for you.
Yep.
But that's really it.
Cool. I wanted to share
one last thing. I'd also recommend that you put a Google alert. You create a Google alert for your brand, for your registered trademark. So that if you do see somebody else, or somebody else is using a similar brand or the exact same brand, you're going to get notification. That's going to be the easiest way for you to police your brand. Is just do a Google alert. If anything kind of comes up under that brand, you're going to get notified, in which case you can reach out to your attorney.
Love that. I'll put that here. Create a Google alert.
Yeah, because most clients, including the vast majority of our clients, are not going to want to pay a law firm to quarterly or monthly police the trademark. They're just not going to do it because it's not going to be worth the money for the most part.
Very cool. And I want to talk about something that's extremely boring but important too. We have a flyer here. Matt, maybe if you can see my screen. We're looking at the maintenance side. Let's go through this if you don't mind.
Perfect. Yeah. So trademark maintenance. So you get the trademark registration certificate. Yay. Champagne corks, confetti, yada, yada, rainbows, unicorns flying everywhere. So what do you have to do then, right? So your trademark rights subsist upon use in commerce. So you need to continuously use the trademark. So if you if you stop selling products for a year or two, you potentially abandon the trademark, depending on the vertical that you're in, right? But that being said, you do have to renew the trademark during specific statutory time periods. So post-registration, between years 5 and 6, you need to renew the trademark by filing what's called either a Section 8 or Section 8 and 15. We'll talk a little bit about that in a little bit. But so between years 5 and 6, years 9 and 10 post-registration, and then every 10 years thereafter.
Okay.
So, 3 times in the first 2 decades, essentially.
Yeah.
One of the things that clients ask about, or, we typically recommend to clients, is that when they file their first renewal during that 5 to 6 year time period, we file what's called a Section 15. Section 15 is a document. It's basically money to the USPTO, but in return for that, you get what are called incontestable trademark rights, meaning that a third party can no longer challenge your trademark for a variety of really important reasons. Some of the more important reasons, like priority of use, some of those things that you could potentially your trademark could be canceled for. If you file the Section 15, it precludes third parties from filing cancellations under those grounds. So really important, especially in highly sought after trademarks or competitive fields,
right?
Or where you might know that there's a third party competitor out there who's doing something similar, right? Maybe they have priority of use over you, but you want to make sure that at the end of the day, like, they can't come after you for trademark infringement. Section 15 is the way to go.
That is huge. So you can kind of, in a way, strategically do it. If the other party is, call it being lazy, and they're not monitoring the market as they should be, they didn't notice you. And it's kind of like, the old property statute, adverse possession. Like, hey, I've been here. Prominently selling your product, right?
I think of like a Section 15 filing as more of like a defensive measure than offensive. You would never have a Section 15 and then use that as a way to kind of enforce the trademark, but it prevents maybe a senior user from enforcing its unregistered trademark rights against you as the junior user who did the right thing and filed the trademark. After 5 years of public notice, you filed the Section 15. So you've done everything right as the junior user. That should not allow the third party senior user who slept on their rights to enforce the trademark against you.
Right.
So it's really a good, peace of mind thing. And it's only a couple $100. So generally it's worth it to most clients.
Very cool. Here's a question here. I saw this come in via the master. Lots of hearts here. Do you accept inventors from outside America? Yes. We have actually quite a few clients. We do only handle federal U.S. patent and trademark law. So if you're seeking a U.S. patent or a U.S. trademark, we can help. Yeah, hugs coming away. Oh, all right. Lots of love. So speaking of that, let me put that quickly in here. And Matt, while you were talking, I was thinking about, our own brand here at Bold. And it's not like you file your app, your trademark, and it just is locked in forever. Markets change, right? The way you market your company changes over time. So isn't it correct? You should probably check in and see maybe now you're moving toward a different brand and refiling and kind of staying on top of it as your company grows.
Yep. And, a lot of clients too. I mean, I have a number of clients who's, they've been in business for 40, 50 years, right? And we still monitor and maintain their trademark portfolio, but they have lots of legacy trademarks before the USPTO did electronic filing. So you have scanned, PDFs, Xerox copies of old logos back from the 80s. As long as you're still using those in some fashion, you can continue to renew the trademark registration. But at some point, if you're no longer using that particular brand and you're already registered for the new brand, new logo over here, maybe you have a word mark that goes back to, 40, 50 years. At some point, maybe it's worth just giving up those old registrations.
Right. But there doesn't make any sense necessarily to file a non-use or you just stop using it. in
Right.
case you want to go back to it and kind of
Yeah, exactly.
reclaim.
Exactly. So, most clients want to keep them if it's possible to keep the old trademark registrations.
Yep.
But of course, they still have to use them in some capacity in order to legitimately say they're still using the trademark.
Perfect. Well, on the patent side, I'll touch base here. This will be a little brief, 4 or 5 minutes here. Some initial things that come to mind as soon as you get the patent granted. Just know that you finally are able to enforce your rights. And I think, as Matt alluded to and talked about, is there is no such thing as a USPTO police. No one or no company, individual, or government is going to go spot and monitor for infringement. That's on you. That is a huge pill to swallow for some of those inventors that didn't quite realize that now they're on the hook to go watch and stay active in the market and go look for those products, systems, methods, processes that might be infringing. So for you to be able to have that time, right, to make an effort to go look for those, make sure that's part of your plan, your business plan. Generally, inventors I speak with have 1 or 2 major routes that they go down. One is a much more passive route toward making money, and one is more active. The passive route is one where you're looking to just hold your rights and or transact with your rights via licensing or outright sale of your patent or patent portfolio if you've been fortunate enough to file more than one. And that can happen through licensing, right? Going and hiring a broker, or you yourself going on meeting some people. Maybe you already know people that may want to use your technology, build it, make it, use it, sell it. And you can construct contracts with lots of different types of clauses, with a lot of different arrangements to allow you to make money, say on a royalty basis, or on net proceeds, or you make a flat amount of money for every unit that's sold. Lots of open negotiation there. And we have just recently hired on, Matt, if you knew Cliff Schlecht. Cliff has joined Bold. He's a patent licensing attorney. That's what he does.
That's cool.
And and there's lots of stuff that happens between inventors and universities, technology transfers, a lot of nuance I won't necessarily have time for today, but post-grant, that's when you start making money. Now, certainly you can start selling, and we encourage sometimes to do that while the patent is pending. And one of the benefits there is that you hit the ground running. Before before that clock starts, you can actually be in the market already and be in the know about infringers. So as soon as that rights get granted, maybe you've already warned potential infringers, and they said, screw you, wait till you get a patent. Now you can go hire litigation counsel and get them for triple damages because they're willfully infringing.
Correct.
Lots of cool benefits to enforcement side. And what's neat is over the past year or two recently, Matt, I've gotten close with Josh Van Hoven, and there's a few other attorneys that do patent litigation and represent the small guy. And you can actually do it. It's not this classic scenario of David versus Goliath. I talked about it when I was on with David, that there's this huge win. Apple, right? The largest company, $1 trillion company, was strangleheld by their Apple Watch sitting at customs because they were violating a patent on the oxygen sensor. A little company in the Bay Area, they're a couple $1 million company, but that's little compared to big behemoth. The customs said, nah, we're holding this. And they were not allowed to sell any of their Apple Watches. So there's a huge benefit.
I remember hearing about that. That was a couple months ago, wasn't it?
It was recent, yeah. And so they finally settled. They were holding out, but it was like a 6-month deal. They got paid. Those inventors, the company that made the innovation, it was owed to them. So shame on you, Apple, and those big companies. There is a win. There's a path forward. You don't need to have treasure troves of money to go pay litigators. The system is set up to reward those that have the rights. So enforce them.
Yeah, and if you have a big opportunity like against Apple, I bet those attorneys were taking that contingent.
Oh yeah, absolutely, totally, great point. You don't necessarily have to come in with a big bucket of money. I'll share my screen really briefly to show the patent maintenance side, and then we'll jump to our live. Let's do a quick slideshow. So in a similar way, you don't just get scot-free on the utility patent side.
Yeah,
you have to pay every so often, and for whatever reason, it's at 3.5 years, you've got to pay some money. And these fees are as of the end of last year, so they may have gone up or down. $2,000, for the regular entity size. Small entity, which is most of our clients, and then some are micro, so you'll pay a really reduced fee, but the fees do go up. So if you're still gaining a benefit, still loving your patent, they make you pay for it as it gets into its more mature years. And round up, you pay around $3,000 or $4,000 to maintain it over the course of the 20 years. Wow. And of course, if you don't pay timely, there's some fees here. And so we have some clients,
if you don't pay these fees, JD, what happens to your patent?
it gets expired early, and we're going to talk about that at our Bold Bite. Actually, it's a great question, Matt. Let's take a look. We have, if you decide to move with a company like us, we have different plans. A lot of our clients say, you know what, I got it. I can handle it myself, and you can handle it. You get all the USPTO correspondence. A lot of clients say, you know what, we'd like to have you on board to help us make sure that we're not going to miss any deadlines, so we don't have our patent expire on us. And so those different plans you can get. We do offer a premium plan as well for some of our clients, which comes with a pretty cool 10% off. Because inventors invent, they'll come back for more, and so we're happy to honor that 10% off for the premium maintenance. Folks, Matt, are you ready to take a bold bite?
Let's do it, man.
Okay, I'm going to switch over our microphone, cue the music. We'll get started in less than a minute.
Stopping for station identification.
Oh, perfect. Here we do. This is awesome. Oh, yes. All right, and audio check. Can you hear me?
Good.
Good, let's launch.
Hi, Sharks. My name is Jules Bindi from Austin, Texas.
Right.
And I'm Carolyn Schufel from Coeur d'Alene, Idaho, and these are our spokespooches, Bentley and Zugo.
We are looking for $100,000 for 10% of Zugo Pets.
We are revolutionizing the way pets travel.
As dog owners, we love to take our dogs everywhere with us. But having your dog sit in your lap, loose in the back seat, or in an unsecure carrier or crate can be dangerous in an accident. In this crash test, these are products that have failed on the market in the crash test simulation. Thank goodness those are fake dogs.
We are passionate about pet safety. That's why we have created the safest way for you to confidently travel with your small pet. We are pleased to introduce the rocket chair bag.
You're velcroing the dog.
Which helps hold the dog in place while you guys are probably thinking, why is he suspended a couple inches above the seat? Which is ideal positioning to protect the spine. Bentley is comfortable, but most importantly, he's safe.
Is he scared in there?
He's just really nervous.
You know what it's like bitching.
This is the exact same test that you just saw those other products fail miserably in. This is our product, the Rocketeer Pack, passing with perfect scores. But that's not all. The Rocketeer Pack comes with front and back attachments. So when you reach your destination, you and your pooch can navigate
I like that too.
together.
I like the other application.
Like a baby carrier.
Safety approved.
How much does it cost?
It costs $160.
Oh, wow, that's expensive. And what's
Is
it
that
cost you to make?
because you're making
It costs us
your-
$36 to make.
Oh, that's a huge margin.
So what are your sales?
Right now, our sales is $180,000, and we just launched it in November.
Where are you selling them?
We're selling only on our website.
So how are you driving traffic then?
It's all organic and word of mouth.
How did you come up with this?
I actually developed this and hold the utility patent on it. The reason why I started this is because I have a dog who has hip and knee injuries. So I wanted to be able to travel with them safely. And I couldn't find anything on the market.
I actually licensed the Rocketeer Pack off of her. I really believed in her project.
So how much money did you put into Carolyn?
Altogether, I put in $200,000.
Oh, wow.
Yeah.
What did you put the money into?
We went into crash tests and production. So far, we have $200,000 worth of inventory.
Who does the day in, day out running of the business?
The point is, you're selling cute when you should be selling against fear. And I think you really have to take your marketing to the next level before I could even consider it. So for those reasons, I'm out.
Thank you all so much for your time.
Thank you. Good luck.
Okay, no deal.
That was pretty funny, man.
They
That's
laughed
pretty
for a
funny.
long time.
Yeah. So, again, listeners at home, this product, Zugo Pet, it's basically a restraining device for pets, that basically holds them like a small child against the seat. It looks ridiculous, but apparently it's effective.
Yeah.
Can you imagine putting your full-grown golden doodle?
No, and
in that?
there was a part, can you hear me okay? I just switched audio. Yeah, I mean, this would be an enormous lift. Kevin O'Leary was like, are drugs involved to get the dog in there? Because they put these small animals. I think that seems more reasonable, but any animal over maybe 20 pounds, 30 pounds, nah, not going to have it. You could just see the dirt, everything, just maybe it's peeing up in the air. I don't know. So one cool thing, though, on the patent side, and it was neat that they do have a utility patent for it. I want to show what happened here. And you can see right on Google Patents, when you research these, it shows the timeline pretty clearly. And I won't dig into the whole details of the app, the patent, but you can see just by typing in the name of the person that pitched, Carolyn Schufelt, as the inventor.
Yeah.
You can go over here. You can see what happened. She filed in 2013. It was an older video. And they probably were on Shark Tank around 2016 or so. It was granted here in 2016, published. So granted actually before it published, but it publishes through the Gazette. And unfortunately, it was expired. So they didn't pay their fees, right? Probably their first 3.5-year patent maintenance. So it's expired early, right? So normally this would have been all the way out to 2033. They could own the rights out to, but it's expired early. And so anyone out there that is interested in this business model, you are allowed. There is no way for them to enforce this patent against you, even though it would potentially have a life that extends well into the 2030s. This is an interesting way. Some businesses, get into business this way and kind of say, oh, some of the patents are expired early. It's part of the public domain. The only catch is sometimes there are ways to revive and abandon, revive an expired patent. As long as you can, if you're the patent holder, if you can explain that there was some financial hardship, some true emergency that occurred in your life. But if you do some diligence, perhaps, and maybe you get something in writing or confirm that there was really no emergency or no issue or fire, right, that caused them to miss their deadline to file, then you're likely free to use it. So I always kind of have a little bit of a caveat there that if you're looking to go to market with a product that's an expired patent, you should certainly go into it with some caution, and maybe even consider looking at other patents as well. You might be stepping on toes of other patent holders, and it may be worthwhile for you to do one of these with freedom to operate. That's what FTO stands for, to kind of consider all of your options, make sure you're not infringing anyone else. But yeah, I thought it was a pretty good pitch.
Good pitch. Kind of a cool product. We actually at Bold have a client who has a pet restraining device.
That's right.
That's all I'll say about that. But pretty cool.
Yeah, right.
People will spend anything on their pets. So
true. I'll soon find out. We're talking about hiring a trainer. Talking about going to get the grooming done.
Yep.
He's got some nails.
Did you get
coming
you get the pet insurance?
No, I didn't know. See, no.
So that would be my recommendation. Is like you just got the puppy, get pet insurance on him, because if he's going to do something,
potential bites or just causing harm to other,
just for his own health, because if he's going to have health problems, it's generally going to be in that first year or two that you're going to find out about him. So our first dog had a lot of health problems the first year, so we wish we would have had pet insurance.
Super wise. Very good.
Might be worth the $60 a month.
Yeah,
for the first year or so.
I'll definitely make that call. Thank you. Good stuff. Well, I think that's about all. Matt, do you want to share anything else on that? Did they file? Did you look up Zugo on the trademark side?
I did. Yeah, they have quite the portfolio. So they have a number of different trademark registrations, something like 4 different registrations, all still live registered. But it doesn't seem like they're. Are they still in business? Did you look them up by chance?
I didn't pull. I could do it right now. I mean, Zugo. Sure.
But I don't know what Zugo means, but Zugo Pet is registered.
Yeah, nothing's popping up. I think they may have fizzled out. Looks like nothing's really showing up. Yeah, but one quick note: there was in that pitch a mention of those two are not necessarily. They didn't start out. There was the inventor, right? That lady. I think her name was Julie. I forget. She licensed, or she basically found this investor to bring this product to market. And sometimes that's what it takes. Obviously, this appears to be a flop in the end, but oftentimes an inventor is not the best business owner. And so that woman knew it, right? She needed some money, some funding, found someone that was willing to put in $200,000. It's a ton of money. And it's a very cool option post-grant for an inventor to go look for ways to move your product to market. And you don't have to do it yourself. You can find someone else, partner up. And that's why I highly recommend getting with a business attorney to get that in writing. Anytime investor money's coming in, when you're joining forces with somebody else, money's involved, take a look and make sure things are written down correctly. Get an attorney. We've got a comment here from Jonathan. Stay away from the Pfizer puppy products. Oh, thank you. I will. I will see what I bought there. I'm guessing there's some not so good chemicals involved. Probably things you don't want to feed your new member of the family. So I appreciate that. Yeah. Good deal. Well, Matt, I think I'm out. We're going to sign out. For all those out there, wishing you a wonderful rest of your day, rest of your week. We'll be around next week. We have a couple guests coming up, 2 or 3 guests lined up this month. Really cool stuff. We have Moo Mycology, a mouthful, but they've got a new way to grow mushrooms, and they have really cool science around that. And then we've got another client that does some racing technology. So pretty cool. Hopefully we'll have a chance to have them on our show next couple of weeks.
Fantastic.
All right, buddy. Have a good rest of your day. Go big. Go bold.
Go big. Go bold at boldip.com.